program is brought to you in association with First National Bank of Botswana. Welcome to First Issues. How many people can attest to receiving a call from a random salesperson on their personal phone lines trying to get them to buy into their product? But then again, you have no recollection whatsoever of giving that particular organization or business your contact details. So how did they get a hold of them? Unbeknownst to you, your private and personal data has been shared with a third party to do with it what they please. The thing is, until recently, there was no law that protected your data from being used anyhow after you had left it with a certain organization for maybe KYC purposes, or like when we were filling out the register at establishments for contact tracing during the strict pandemic restrictions. As of October 2022, the new Botswana Data Protection Act came into effect in efforts to, amongst other things, prevent such scenarios from happening by holding those in possession of such data accountable. While that is the gist of this new law, there's still so much more to unpack. And to help us with that is consumer rights activist at the Consumer Watchdog, Richard Harriman. Richard, thank you so much for coming on First Issues and affording us your time. We are talking today about the new Botswana Data Protection Act. Perhaps before we go any further into our conversation, you could explain to us what it is and what it is trying to achieve.
I can talk about what it's trying to achieve. Obviously, this is quite new. I mean, okay, let me correct myself. It's not new. The Act was passed in 2018, so 4 years ago. But it hasn't been it's not fully enforced yet. The commission that's been set up to enforce the Act is there. We have a commissioner, but it's yet to be fully enacted so that it actually affects our day-to-day life. What the Act does is actually very simple when you think about it. It talks about the control of data on individuals like you and me. And it requires organizations like banks, insurance companies, telecoms companies, like cell phone network providers, restaurants, the government, whoever's holding data on us. It forces them to do a number of things. It forces them to decide and then record and monitor what information they're holding on us. It requires them to think about why they're holding it. They've got to think about how they store it, how long they store it, where they store it. You're going to store it in Botswana, you're going to store it in China, you're going to store it in Mongolia. You've got to decide those sort of things. You also they have to decide how long they're going to record it for. So do they record it forever or for a year or 7 years? They also have to decide and record who they're going to disclose the information they hold on us to. So you think of a bank, for instance. A bank will potentially share the information it holds on you with the tax authority. It might share it with the Financial Intelligence Agency if something suspicious happens. They might share it with TransUnion and others. They have to declare who they will share the data with. They might share it with other banks. They might share it with market research companies. So all those times you get phone calls from a market research company saying, we're evaluating the service from your bank. Can you answer these questions? They've given your identity and perhaps some of your details to a market research company. I know this because that's what I do for a living. But they need to think about and define what they're recording and what they're going to do with it. And in particular, the Act is quite specific about the data that they record. We're not talking about the weather. We're talking about personal data, it defines. And personal data it defines as the basics: your name, your ID number, where you live, your date of birth, all those basic things, your gender, maybe your nationality. It then goes on to define, more importantly, what it calls sensitive personal data. And these are things like, that are a bit more dangerous perhaps, things we wouldn't want shared with the entire world. Things like our ethnicity, our political opinions, our religion, our sexual orientation, our physical or mental health records. This is sensitive stuff. The other thing the Act does, which I really, really like, and I'm looking forward to this side of it, is that it imposes penalties. If organizations misbehave with our data, if they disclose it to someone they shouldn't be disclosing it to, so they can disclose it to market research companies only if they've said they will. So if they disclose it to someone who they shouldn't, or they don't obey an instruction from the commission, there can be penalties. And those penalties can be quite simple, like the commission can go to the bank and say, fix this mistake. This information is incorrect, fix it. They can even be instructed to delete information if necessary. But then there come the real penalties. The penalties in the Data Protection Act vary depending on what sort of offence you've committed, what offence an organisation has committed. The entry level, level 1 on the penalties, is a fine of 20,000 pula, 1 year in prison or both. That's the entry level, 20 grand or a year in prison or both. Level 10 on the penalties, the highest level of penalty, is fines of 1 million pula and 12 years in prison or both.
Our conversation today is going to be is really centered around the consumer, or the benefits of the act for the consumer. And one of the things that it's trying to do is to empower consumers to have some sort of control over what happens with that personal data, right? But one may wonder, when is that power or that right over personal data relinquished?
We have to be realistic about this. Maybe some of us would think in an ideal world, nobody holds data on us. We want to be entirely secret and confidential. We all like privacy. We all like the privacy of our home. We all like the privacy of our bedroom. We all like the privacy of our sitting room. There are limits to that. We relinquish our rights under this act to some extent when we agree to relinquish those rights. So if I go and open a bank account, obviously the bank's got to hold some information on me. They've got to hold my data, my basic data, the personal data, like who I am and where I live and who I'm married to and my date of birth, those sort of things. They also have to hold personal data, sensitive personal data, like every time I swipe, every time I spend money, every time you send me money or I send you money. They've got to hold that data, otherwise my bank account wouldn't work. So to some extent, yes, we relinquish our right to privacy in order to function. We're using online tools, we're using cards, we're using all sorts of things with our phones and our watches to transfer money these days. We have to be practical. We have to relinquish some rights in order to function. And we have to accept that organizations do need to do things. Banks are required to record every transaction. They're required by the Bank of Botswana, they're required by FIA, the Financial Intelligence Agency, to monitor what we're doing, because they're trying to prevent money laundering and terrorism and all these things that we want to help them prevent. So it does mean, I hate to say these 3 letters, KYC, because we all find that really irritating. But it's got to happen, because banks don't choose to do KYC because they think it's a great idea. They do it because they have to, because if they don't do KYC, Bank of Botswana is going to shut them down. FIA is going to shut them down. So yes, we relinquish some rights when we hand over this information. But I think we also relinquish rights when we don't use our rights under the Data Protection Act. So maybe not every day, maybe not every week, but maybe once a year, maybe once a couple of years, we now need to be going to our banks, our telco companies, and saying, show me the data. Show me what you've got on me. Go to credit reference bureaus. And some of them do this already, but go to them and say, show me my record so I can check to see whether it's accurate. So we relinquish our right to privacy, but we also have the right to monitor what's being done with our information.
With every right, there's a responsibility. And with any new development or anything that is new, there tends to be some teething challenges. So I don't know if you think there are any gray areas or gaps within the new act that consumers should be aware of, lest they find themselves on the wrong side of the law.
There are a couple of things that struck me that I think may be grey areas or we need to think through. In that the Act talks quite a lot about whether data is held in Botswana or whether it's held overseas. Now, that sounds great. Ideally, data should be here. Or should it? It's 2023. Whether we know it, many of us are now using cloud computing. When we synchronize our phone and it syncs with our laptop or it syncs with other phones, we're using cloud-based technology where the data on our phone is stored somewhere. It might be stored who knows where. That's one of the great things about technology these days. The cloud thing just works on the whole. And we don't need to know about what type of server it is and whether it just works. And what I wouldn't want to see is a situation where we as a country, in order to protect ourselves, log ourselves out of the cloud. It's the modern era. This is how things work. So hopefully the Commission is going to be pretty flexible and open-minded about, okay, if a bank, a telco wants to store data on a cloud-based server somewhere, and maybe that's one of those servers is in Botswana, in a data center somewhere, but it's also backed up to a data center in South Africa, or these days it can be in Brazil or Mongolia or Australia. Just, we need to have some flexibility about that. So I don't think it's a gap, but I do think we need to be practical and realistic. We live in the modern era, and we need modern era tools to work. One other thing, I was in a meeting talking about money laundering, and one of the issues that came up was some of the less reputable car dealerships are holding only manual records. You go and buy a car, and that record isn't held in a computer system somewhere that I spent 30,000 on a Honda Fit. It's held on a piece of paper in a ring binder on the shelf. Now, I'm not sure the Data Protection Act can control that because it's not computerized. It's just a piece of paper. So I think we need to be careful about where data. I don't want data suddenly to go back onto bits of paper because that's a little outdated and a little bit crazy. Mm-hmm. So I think the key thing is we need to wait and see. How muscular is the Commission going to be? Hopefully very muscular. And are they prepared to get their hands dirty? I hope they will be.
Before we let you go, Richard, why exactly should this be important to anyone? Why should they care? And why do you hope that the Commission will come in with a whole lot of muscle, like you say?
In the past, our identity was based on physical things. We had an ID card. We had a passport. We had a card from our employer sometimes. I used to have a government ID card. And that was our identity. That represented our identity. These days, yes, we still have passports and ID cards, but our identity now is very much online. We all have Facebook profiles and Instagram profiles and email usernames and passwords. So much of our lives these days is online. And we have to have a legal framework that protects us in that area. So our identity and our life is online these days. Gone are the days of printed bank statements. It's all on a computer somewhere. And we need a legal framework surrounding all of this that protects us. And in particular, things like our digital identity. So our Facebook profiles, our Instagram, Twitter, TikTok, whatever profiles need to be protected. And we need an act like this that controls how it's managed. It's great that you go to your local doctor and he or she can go onto a computer and say, here's the results from the hospital over there. It's no longer bits of paper. It's really sensitive, some of this stuff. It's our HIV test results. It's our lifestyle health issues. It's all sorts of blood test results that are now online. So we need to be incredibly careful about who has this information, who has access to it. What are they doing with it? Who's sharing my blood test results with other organizations? Does my life insurance company know about that blood test I had last week? Maybe they have a right to, but I need to know that they have that right. And we need the protections that we can all rely on. And critically, we need to understand those laws. So I think this is a great opportunity for us to start talking about what the Data Protection Act and all the other laws that protect us, what they say, and how we can use them.